Florida, anyone can request a public record for any reason or no reason at all. Section 119.01 subsection 1 provides that it is the policy of the state that all state, county, and municipal records are open for personal inspection and copying by any person. And the term person is broadly defined to include not only individuals, but all other groups or combinations of people. For example, public employees meet the definition of persons who can request public records. And public officials seeking to use their public office to have a chilling effect on a public employee's ability to request public records can result in serious ethics consequences under the misuse of public office prohibition. Similarly, a county was determined to be any person who is allowed to request public records. And in Florida, there is no distinction between a Florida citizen and a non-citizen for the Public Records Act purposes. In fact, a former citizenship requirement was deleted from the law in 1975. Thus, both courts and the Attorney General have found that the law provides a right of access to public records to any member of the public, whether the most outstanding civic citizen or the most heinous criminal. In truth, there are few public records request requirements. Public records requests may be made orally, either in person or over the phone, or in writing via almost any medium, including emails. For this reason, it is important that all public employees, especially those who interface with the public, should receive public records training to ensure that when a public records request is made via whatever medium, the records custodian is apprised of the request and a prompt acknowledgement of the receipt of the request is made to the requester. Frequently, litigation results from public records requests being made to agency personnel who is unaware of the public records process adopted by that agency, and thus the request languishes. Further, agencies cannot require that certain forms be used in order for a person to make a public records request, and agencies cannot impose unreasonable restrictions upon access to public records. As we will discuss soon, an agency can require the payment of fees authorized by law prior to public records being provided. In order to mitigate costs associated with public records requests, requesters sometimes ask to see the records in person and to take pictures of them, thereby effectively making their own copies. And the Public Records Law, Section 119.07, subsection 3, provides an avenue where this medium can be authorized. It provides that any person shall have the right of access to public records for the purpose of making photographs of the record. However, agencies are permitted to adopt reasonable rules and policies regarding such photographing of public records, and they can require that the records custodian be present to supervise the photographing of the records. Further, courts have struck down requirements that a requester be made to explain the purpose or the reason for requesting the records, and have instead held that an individual's reason for requesting a public record is irrelevant. Similarly, the Attorney General has found that requesters of records cannot be required to disclose their identity or background information regarding themselves, such as their name, address, or telephone number. Pursuant to the requirements of Section 119.012F, an agency must provide a copy of the record in the medium requested if the agency maintains the record in that medium. For example, if a public records request is made for certain complaint filings, which are maintained by the agency in both paper and electronic format, and the requester asks that they be provided via email, the agency should provide the records in the medium requested, here electronically, as the agency maintains the records in the electronic format. Further, public records requests cannot be denied for being overly broad or voluminous. The Public Records Law provides a right of access to public records that exist at